I don't know if that answers your question, but
Not really.
That's the most.
Let's try it again. Is that your testimony?
Yes.
You had forgotten. You remembered Matt and you remembered Carrie, but you had forgotten the others that you had just contacted maybe 30 minutes before. At that time or after, did my client even approach you? Did she, in that clip?
She did.
What?
I answer the questions I'm asked.
At 6 a.m. when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know. Where's the judge's signature? You don't get in trouble or get spanked or get slapped or get fined. But that's not at all what you told Trooper Proctor on February 8th, just 10 days after this incident, is it?
I don't recall what I told Trooper Proctor.
I thought your memory got better with time. Get over it. Well?
I'm still... Maybe some of the words that I use may be different, and I don't remember on specific days. We've been questioned many times, but the answers are always going to be the same. The wording may be different.
You done? Finished? Is that answer?
Yes, I am.
Okay. I'm going. Nobody ever threatened you with perjury, did they?
Oh, they did. Yes.
That's it.
I contacted the FBI regarding it.
Oh, did you?
I did.
You have a report? That's a mouthful.
Yes.
My question is, do you have a report from the FBI saying that you reported that someone on the Fairview defense team threatened to charge you, your words, with perjury? You have a report to that effect?
No.
No. And your entire job revolves around what you say on that witness stand. That's what you said, correct?
I don't know if that answers your question, but
Not really.
That's the most.
Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Get over it. Well?
I'm still...
That's what you just said, Officer Deborah, correct? The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. You were asked by Mr. Brennan, give me one name, very dramatically. You were asked, give me one name. Remember that? Get over it. Well, that question?
Yes.
How about the name Judson Welcher? How about that name?
I answer the questions I'm asked.
Two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse
not
me.
What no, I'm not going to.
So I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to your
argument. How about
argument.
if I quote his words? How about that?
Technically.
Technically?
Yes,
It's like being a
technically.
little bit pregnant, Ms. Roberts.
I answer the questions I'm asked.
Correct?
Yes.
Who charges people with crimes?
If a crime is committed, there can be a report of it.
Who
So,
charges people with crimes?
in the end,
I don't know if that answers your question, but
Not really. Get over it. Well, would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. With her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Lapisada to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand as a scorecard. You didn't know if they were asleep. All you knew was there was a severely injured man on the front lawn of their house, and your sister didn't answer the phone, not once, but twice, correct?
Correct, she didn't answer the phone.
Did you think your sister might have been in peril? Did you think to go inside the house and check that they're okay?
I had no reason to think that they weren't okay.
You had no reason to believe they weren't okay. A man was dead or dying on their lawn, and your sister's not answering the phone.
that's not a yes or a no answer.
Well, yes, it actually is, Miss Deborah.
There's nothing nefarious. remembered who I called. I didn't go back and look at phone records.
I didn't say it was nefarious. Why would you use the word nefarious?
I don't know if that answers your question, but
Not
that's,
really. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
I answer the questions I'm asked.
Understood the question.
And you misunderstood that question?
Yes.
What
I
did you
did.
misunderstand about that question?
I didn't know it was that you heard, so I was explaining what happened in the back of the car.
I see. So you just ignored the part, literally, the part of the question where he said, what did you hear her say? Higgins spent a quote, wildly long time, as she described. These are all incredible details to tell law enforcement.
I don't know if that answers your question, but
Not
that's,
really.
that's the most.
I answer the questions I'm asked.
That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress up in John O'Keefe's clothes? Well,
So no.
might have been a
I
good
disagree.
idea to sit Mr. Albert down and say, there, you're shaking your head again. I'm not done with my question. Might have been a good idea, Mr. Gallagher, since you happen to be there, no sweat off your brow, to sit Mr. Albert down and say, by the way, I got a pen and paper. Who was here last night, just before John O'Keefe was found dead on your lawn? Who was here? Might have been a good idea, correct? So, you ever seen a defense attorney charge someone with a crime, ma'am?
I'll never forget it.
You wouldn't overlook that.
I will never forget it.
You would not overlook that either, would you, Ms. McCabe?
I answer the questions I'm asked.
Can you answer the question that I just asked? You're not answer my question. Get over it. Well, how is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog.
Over. So yes, you can get in trouble.
You're talking about lying in an affidavit, sir.
I'm talking about misleading.
Correct.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape, and she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Do you want to be here tonight?
I have no relation to this case,
I
so
didn't ask you that. I asked you if you want to be here tonight.
I answer the questions I'm asked.
I don't know if that answers your question, but
Not
that's,
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We got to talk about true crime.
Hello, hello, hello. How you doing? Did you enjoy that? Good morning, madam. Good morning. I'm up and early. Mm-hmm. Yep. You don't know what I had to do to achieve said time restraint. But they are all alive still. Good morning. Hey? What was that? Oh, no. I changed the, I actually thought that was a video that I'd put up as an intro, but it wasn't. It was the compilation I did of Alan Jackson, but that's all right. It gave me time to put up a couple of other things, and I really had to dig for some stuff that I was looking for. I know I had it because I'd actually I'd streamed it before and I'd saved it, but I've sort of over the last couple of weeks I've been transferring a lot of my older trials and stuff I'm not working on anymore into my Google Drive to clear up space on my computer. And yeah, I didn't know which location things were at, and yeah. Anyway, doesn't matter. I found them. And Excuse me. And I kind of went down a bit of a rabbit hole as well. So I've got some additional information. But today we're going to focus on the two main things that I have found that really implicate involvement, basically, of the MCALBERTS, and it tells me that there was planning and manipulation from the get-go, and also it shows me that there may also have been some type of resuscitation attempts made prior to his death. And I will explain both of them with receipts. So grab your drinks, grab your blankies, grab whatever it is you need to get comfy, because we're going to buckle in, buckle out, buckle down, and get this, debunk this theory, because this is something that I've been working on for a long time. And it was initially basically me just saying, common sense. A Boston police officer with fire, ambulance, police, bright lights on his front lawn, and he doesn't leave the house. That doesn't compute. Sorry, doesn't make sense. He's a detective. He was actually a sergeant and a first responder as well. So there is not a chance in God's green earth that he did not know that there were these people on his front fucking lawn. I'm sorry. End of story. So I asked myself, why? Why would he not come out? There had to have been something that benefited him alone, or the situation. And it took me 8 months, but I found it. We all know that Massachusetts is pretty much a law unto itself anyway. Oh, wow. Oh, where'd that go? Holy crap, Tricia. So I've been monetized for 11 months. No, that was the 500 subs we could start memberships. Is that right? I don't remember. I've slept since then. But thank you. That's awesome. Wicked support. Thank you very, very much. You know, you're the OG. You're the real thing, the real deal. Miguel. Me Kentucky lass. And we're working on a little project. Well, not a little one, a big one behind the scenes. So stay tuned for that, because there's big plans for next week. Just saying. Right. Now, I've probably gone about this ass about, because I've set up all the... Doesn't matter. I can do this. All right. So, me and my question. Why would he not come out of the house? What could possibly benefit him by not doing that? So, this is what I stumbled upon when I asked the question. Okay. That's probably a shit view. Let me... Nope, that doesn't make it better. No, that doesn't help either. God. All right, let me just adjust this. I need to be able to read it. Okay. That's about the best you're going to get it, I think. I'm distributing over here. All right. That'll do. Margaret. Okay. So it says the Massachusetts Declaration of Rights. Now, in Massachusetts, they have not only they're bound by the Constitution, but they have additional local, they're not laws, so to speak, but they're like the Declaration of Rights, which are over and above that they are specific to Massachusetts, of course. And in amongst those is Article 14, and it pertains to the rights of property owners when criminal acts are done on their private property. Right. So I asked the question, what is the impact on Brian Albert's actions with the use of the Article 14 from the Massachusetts Declaration of Rights, which was adopted in 1780? So the Declaration says every subject has a right to secure from all unreasonable searches and seizures of his person, his house, his papers, and all his possessions. All warrants, therefore, are contrary to this right. In other words, if you don't have probable cause to search or seize, you don't have a right to do that from the police, from law enforcement's operation, right? So they could not do that unless they had probable cause. And because John's body was on the lawn, there was no real probable cause to enter the house. Unless someone had said that the perpetrator was seen entering the property, or that they believed that the murder weapon was dumped through a window or something like that, that is probable cause. Otherwise, they cannot do it. They would have to go through the necessary procedures in the judicial system to apply for and obtain a warrant. And we all know that takes time. And that's exactly what Brian wanted. Time. You have time then to clean. You have time then to get all your stories straight. You have time then to decompress. The more time you have, better it is. Right. So, next bit. All warrants, therefore, are contrary to this right. If the cause or foundation of them is not previously supported by oath or affirmation, and if the order in the warrant to a civil officer to make search or suspected places, or to arrest one or more suspected persons, or to seize their property, be not accompanied with a special designation of the person or persons objects of search, arrest, or seizure, and no warrant ought to be issued but in cases and with the formalities prescribed by the laws. Now, that's actually just an extract from the actual article, so that sounds a bit mumbo-jumbo-y, but let's break it down. So, the Article 14 is very similar to the Fourth Amendment of the US Constitution, but it is over and above that. Okay, it's an extra layer, additional padding, so to speak. But it's historically been interpreted by Massachusetts courts to provide even stronger protections against unreasonable searches and seizures in some circumstances. So, Brian Albert's role in the Karen Read case, he was a Boston police officer who retired in 2023, and he owned the home in Canton at 34 Fairview Road, Massachusetts, where John O'Keefe's body was found on January 29th. Now, as we all know, the Karen Read claims that she dropped John off at the Alberts home for an after party. The defence's theory suggested that O'Keefe was killed inside the Albert house during an altercation possibly involving Brian Albert, Colin Albert, and Brian Higgins, and others at the home, but they denied that O'Keefe ever entered the house. That morning, potentially relevant to Article 14, based on the available information, several actions that occurred on that morning O'Keefe's body was discovered might raise questions under the Article 14. So it limited the initial search of the scene. When the police responded to that scene where O'Keefe's body was found, they did not immediately search Brian Albert's home. Officers allowed Jennifer McCabe, a witness who'd been at Albert's house earlier, to enter Albert's home to wake the residents up before letting themselves in. Now, you remember, after everyone had gone and John had left in the ambulance, that's when Jen decided she'd go in and wake up, sleepyheads, Brian and Nicole. And Dad was surprised. Oh, what are you doing in my bedroom? Goodness me, goodness me. No Chloe, no dog barking. Funny. So she goes in, and once she's entered the property, the police then entered in after her. But again, they're not allowed to search. So I think they stayed pretty much in the kitchen area of the home from memory. So she went into the house to wake them before the police themselves entered. Police conducted a brief, unrecorded joint interview with McCabe and the Alberts together inside the home rather than separating the witnesses. There was no search warrant issued for the house, and it was not searched. It wasn't searched at that time. Officers later testified they had no reason to believe O'Keefe had ever been inside, thus no probable cause for a search warrant. So a daylight search of the Alberts' front yard was conducted after the snow had reportedly been cleared with a leaf blower. Well, we don't need to read the rest of that, I don't think, because it's not really... connections to investigating officers. Some responding officers had personal connections to the Alberts. Article 14 requires searches and seizures to be conducted impartially. The manner in which evidence was collected, particularly the timing and circumstances of finding pieces of reed starlight after the snow had been cleared from the yard, could raise questions about whether evidence collection followed proper protocols under Article 14. Article 14 recognises that consent is an exception to the warrant requirement, but questions might arise about whether proper consent procedures were followed, given Albert's relationship with investigating officers. Legal implications. The defence attorneys in cases like this often challenge evidence under Article 14 if they believe proper search and seizure protocols weren't followed. Now, I actually just went back and had a listen to the initial testimony. Let me just add this one instead so we can read that. Oh, I think was it Gallagher who... I can't remember who the first one was, but I was listening to it anyway. So what Article 14 protects Brian Albert from? Staying inside his home does give him a level of constitutional protection, but only in certain ways. So the police, they cannot search his house without a warrant unless there is an emergency, consent, or probable cause. Being inside doesn't automatically protect him from questioning or scrutiny, but it does limit what the police can do without legal justification. If he didn't witness the crime, wasn't involved, and didn't assist anyone afterwards, he is not criminally liable just because it happened on his property. Yeah? Making sense now? Would he put himself at risk by actually inserting himself into the scene outside? Not on your fucking Nelly. All right. What it doesn't do, it doesn't shield you from investigation. If the police believe that they saw or heard something, then they can question him and they can obtain search warrants. And if evidence or suspicious points to his involvement, his location inside the house, it won't stop a further investigation. But again, you need a warrant or a legal cause to do so. Hey, Christine, how you doing, sweetheart? So if Brian Albert had come out of his home while John O'Keefe was being resuscitated and law enforcement and first responders were on the scene, here's how things shift under that. He has less protection in the public view. So the moment that Brian steps outside, he is no longer protected by the same level of privacy as he is inside his home. Article 14's protections are strongest within the home. Once he's outside, on his lawn, driveway, sidewalk, wherever it may be, his expectations of privacy drop. So, if he's outside during an active crime scene or emergency, police can approach him, ask questions, and observe anything he says or does without a warrant. And that can be used against him. He can still choose not to speak, but he's now in a space where officers don't need legal justification to engage with him. So coming outside doesn't mean that he's given up all of his rights. He still has his rights under the Constitution as well, and he has the right to not answer questions. He can't refuse consent to a search of his home or belongings, but unlike being inside, officers don't need a warrant or exigent circumstances to initiate contact. By being outside during the emergency, he could now be seen as a potential witness, and anything he says or does could be noted, recorded, or used in the investigation. So the bottom line is he stays inside. The strong influence of Article 14 allows extra protection, and the police need a warrant or legal reason to enter said premises. So that is perfectly ideal for Brian Albert. Why would he come out? If he was outside, there is far less protection. He becomes visible, accessible, and immediately part of the scene in the eyes of the law. It's as simple as that. That is why he did not come out. Now, there's one more I've got here about homeowner liabilities and stuff in the criminal cases. So proximity to a crime does not imply guilt, and simply owning or residing in a property near where a crime occurred does not make the homeowner criminally liable or automatically subject them to scrutiny. Law enforcement must have probable cause to investigate or implicate a homeowner in relation to a crime. Now, as I said, I was looking back at the testimony of one of the first police officers at the scene, and he was saying in his answer that he couldn't shift. Actually, is it this bit that I've got here? Let me have a look. Bring it up for you, because it seriously was like, now the only way I could save this was to just so let me mark that down. 1840. Sure, I have trial. We're going to take a trip back in town, folks. A trip back in time. We're going to go to Karen Trial 1. Coverage from the defence rests. And have a look at the difference in the change between then and now. There was a testimony here somewhere. Anyway, let's play this bit here. I hope she doesn't copyright me. Let's share this. Share screen. Oh, my head. These keep coming off. Share screen. Add to stage. Oh, okay. There we go. Look at that. All right. This is my presentation from last trial. Okay. But it's the time frames that a lot of them, or not a lot of them, we can't confirm Brian Albert, we can't confirm Brian Higgins, because their phones miraculously disappeared. So I've gone on the timeline of what their testimony has said with regards to when they arrived and when they left. All right. So, and in my opinion, Chloe was there too. So, no, she wasn't actually. No. Let's go to the next one. All right. So we have the 34 Fairview Road, we have the house, and we have the vehicles where they were apparently located. So, as per Karen's timeline, she arrived at about the 12:15 mark, and I think they had a bit of an argument as to she didn't want to go in. Okay, hang on, I'll fix the echo. I know what that is. We've gone back in time. This is my presentation for the first trial on what I believe happened. And we're focusing on two particular things that I have found. You'll just have to watch. John's decided he's going to go in without her. Yep. He goes inside. She hums and ha's for 10 minutes or so and leaves because there is CCTV footage from the city library that was given to the prosecution in a digital format, and when it was supplied to the defence, there was a 2-minute period at 12:28, between 12:28 and 12:30, that was missing, and it had been burnt onto a CD. Yeah, blah blah. Get on with it, lady. Defence, and 12:28 would have been the time that Karen Reid's car would have driven past that city library on her way back to the meadow, and it would have shown. Look how boring my backdrop is. Intact tail light. So that's the timeline that I've gone on with regards to her presence there. Now, Ryan Nagel, Julie's sister, brother, them said that they went down to the basement. Right. Okay. Actually, I might have to move myself off this. The defence's third-party culprit. Who did they nominate? Who? Oh, I wonder. Would it be these three? Perhaps. Am I psychic? No, just clever. Screen there. Oh, I've got a bigger photo. It's okay. So I think the two Brians were downstairs looking at the photos down in the basement, and I've put a picture there of the basement. I'll show you at Brian Albert's place, and I reckon that they'd set it up pretty much like a man cave. That's where the boys go and drink the beers and what have you. So I think they were downstairs in the basement, having a chinwag with Colin, and Chloe had gone down to be with Dad. All right. And then John arrives, and John goes, "Oh, we're the boys, You just need imagination." Downstairs. He heads downstairs. All right. Stay with me. Stay with me. This is my theory of what happened. Next one. At the first trial. So, as I said, graphic content warning, just be wary. I have to move myself off. Yeah, I moved myself off and didn't realise that when I did that, you couldn't fucking hear me. So I waffle on for about 5 minutes before I realised, and then say it all again. I'm a dickhead. So basically, I'm saying that he was pushed, and the actual wound itself, given the size of it, my theory was that he could have landed on one of these support brackets that were in the basement, for the weights to stop them from lifting, from falling. So, look, who commented. So that's how I explained how I thought he obtained that blunt force injury, basically. So let's keep going.
We'll go back to the basement. All right.
What are we doing?
So,
no, I repeat myself here.
Yeah, runs downstairs again. That's 3 flights of stairs.
Oh,
All right.
hang on.
So CCTV footage. Mind you, no footage from anywhere up the street, across the road.
And at 34 Fairview. And he had CCTV cameras. There are 2, at least, at 34 Fairview. And they were not ever presented at trial because that would have shown. Gabby was a mod I had at the start when I was working with AJ.
There is, if you go on to anyone that's researched the case, pretty much they've done a walk up of the street and shown all of the CCTV cameras across the road that would have had a clear view of the comings and goings, and none of it was ever recorded. So he goes downstairs to see the boys, okay? Then he's realised, oh, bugger, I forgot my beer. I'll go and get one from the kitchen. So
I'm trying to explain the 3 flights of stairs that he ascends and descends in that time on his phone data.
Off he goes upstairs again to the kitchen, grabs a beer, runs downstairs again. That's 3 flights of stairs. All right? That explains that. Now, just remember these here. Okay? I'll come back to it, but just remember them there. All right, this is my theory. So 12, the 2 Brians arrive, and Colin Albert, they go downstairs to the basement, and Chloe follows along. At 12:13, the McCabe's leave the Waterfall bar. That is off Jen's phone extraction. 12:15, John and Karen arrive, but only John goes inside. 12:18, John calls Jen's phone back because they'd been texting and calling, and it had been answered. So he was alive at 12:18. 12:20 is when Ryan, Ricky, and Heather arrive to pick up Julie, and none of them see the Jeep owned by Brian Higgins. 12:21, John goes downstairs to the basement to see the boys, as I said. 22, he goes back upstairs to get a beer from the kitchen and returns to the basement, and that accounts for the 3 flights of stairs that show on his Apple Health data. Now, from then on, something triggers an argument between John and one of those 3 men, whether it's Brian Higgins bragging about the text messages to Brian and John overhears it, or someone said something, I don't know, that's my thought, but something starts an argument between John and someone else, and a fist fight ensues. Now, it had to have involved Brian Higgins, because that would explain why Chloe would get involved. So if someone's trying to hit
Albert, not Higgins.
Brian Albert, then the dog's natural response is to protect their owner. So that would explain why we have the lacerations to John's right arm, and I will show you a picture of that in a second. And at some point when he's hit in the face, he falls backwards, and that is enough to push him backwards and hit his head onto that gym equipment that was there. Now, I'll go back that one. If you have a look at that, I'll see if I'll do it full screen in a second, and then I'll come back to it. But those bars where the weights sit is pretty much 2 inches, which correlates to the size of the laceration on the back of John's head. Now, as we all know, head wounds bleed like a stuck pig.
Mm-hmm.
So he would have hit that really hard, because in the photo it looks like it's really deep, that wound. And that would have rendered him pretty much unconscious. And I believe that he's fallen backwards onto one of those bars, and he's then slid down into a semi-upright position, and that's when he starts to vomit, and that's why there is no vomit in his lungs when the EMTs find him, and that will explain why the vomit is on his pants.
Just bear with me. This is 12 months ago.
And then, yeah, well, this is their actual gym downstairs, and I've got some more photos. Hang on, stay with me. Stay with me. All right, so I'm gonna have to make that big. So he falls backwards onto the gym equipment, and that renders him unconscious, but leaves him semi-upright. And then at 12:32, that trauma, the head trauma, causes him to start vomiting and start having a seizure. Now, that seizure, I think, is what the 36 steps on his iPhone records. That's my theory. And I think he may have had that phone in his hand or in his pocket or something, and the 36 steps right then were the actual seizure that he was having. And from that point on, I believe that the phone was initially switched off by whoever was in the room. My theory. Next one. So at this point, Brian Higgins, who is now a witness, an accessory, and Jen go into damage control.
All
right. So Jen
the next
Horn
one
and
was
placed him, but
some
something
pictures of the site where his body
and
was.
it explains why there is.
And with the head wound that he had, and with the autopsy results that we acquired later, he had actually lost 3 liters of blood. 3 liters from that head wound. So there is not 3 liters of blood at said crime scene, initial crime scene. Well, now this is him at the hospital after they have tried to resuscitate him. Now they had to obviously rewarm his body to get it back and try and get his heart working again to be able to declare him dead. Now, a lot of people have seen this picture and put the bruising around the eyes down to a fist fight, which is not the case. A fist fight bruising, you get the whole area basically, or you get gravitationally underneath the eye. And particularly if he was hit by Brian Albert or Brian Higgins, both of them are big boys and both of them have boxing experience. So if they were going to connect a punch with his face and both eyes, so there would be a left hand punch and a right hand punch, then there would be some, I'll guarantee you, some splittage of the eyebrow where the bone, where it's not meaty. You know, you get the nice split eyebrow from an impact. He does have a very, very small laceration on his right eyebrow, and that's where I think Colin Albert comes into the play. I don't think Brian Higgins or Brian Albert laid a hand on him to punch him. I think there may have been some kind of argument regarding Karen and Higgins, and I think Colin Albert was being lippy, and I think the laceration to his right eyebrow was from a wussy, weak-ass punch laid on him by Colin Albert. And the reason I say that I believe Colin Albert is involved is because there is not a hope in hell that Jennifer McCabe, Nicole Albert, or the other sister, I can't remember, would perjure themselves in court to protect Brian Albert or Brian Higgins. The only way that they would do that is to protect a child. That was my working theory back then. So then we've got some more pictures. So basically, John's injuries here are caused by the blunt force trauma, the force of that blunt force trauma to the rear of the skull, and the impact of his brain being projected to the front side of his skull internally and causing that to bruise and bleed. Okay. And then because the skull is an enclosed capsule, the only place that it can really expand is through the eye sockets and down through the base, the brainstem where it joins in to the spine. And we know from all the autopsy stuff that he did have massive subarachnoid hemorrhages and internal hemorrhaging and all sorts. So now, this is photos of John's hands. Now, these bruising here, obviously done pre-mortem, which means they were done before he died. They indicate they've been put down to defense wounds. Now, that's all well and good if you're giving someone a backhanded slap, but that's not where the impact zone is when you're laying a punch on someone. Yeah? Are you digging my vibe? So, we have some lovely photos of those, but that's what they've been put down to. They were attributed to no, there's nothing more on that. They were attributed to as defensive wounds for John. Now, let's get a closer look, shall we? That is John's right hand. Let's go even closer. What's that? Did he get bit by a snake while he was on the front lawn? Now, I will admit, I actually put this down to resuscitation attempts to gain IV access. And that's where I left it, pretty much. But it dawned on me. If first responders had tried to attempt to IV access once they'd picked him up and put him in the ambulance, he would not have had any bruising because he had hypothermia and his heart wasn't bleeding. Did I say his heart wasn't bleeding? His heart wasn't beating. So it would not have bruised. Plus, there is not a first responder on God's great earth that would attempt to gain intravenous access to the furthest part of a periphery of a limb that has been exposed to the cold and obviously shut down, because that's the first thing the body does. Vasoconstriction puts all the blood into maintaining the vital organs. So anything from your extremities gets shut down pretty much to save that blood. And he's hypothermic. They would have to be damn right stupid to even try and attempt IV access in one of his arms or legs, right? So, you see that one? Is that one better? So that then means that wound, two nice little points, little needle prick points, had to have been done before he died. So then I thought, well, hang on a second, you can't. Like, that couldn't have happened. There wasn't a nurse in that. What the fuck? Wait, there was. There was a fucking nurse in there. Sarah Levinson. And lo and behold, Ryan Albert's a qualified first responder. Who knows what stock he had in hand for first aid? So there you go. If you've got a better idea on how those two little marks were or what caused them. Because everyone's focused on, obviously, the arm bias. Oh, the other thing, they would not have done an IV access here because, and I have proof, ready? They had this in. He had the ones directly into his bone. That's what they put in. Mm-hmm. You combine that with Article 14 and Brian Albert's behaviour or choice to stay inside, which allows him additional protection and additional time, which is exactly what he wanted to have happen. Yes, he does. He does. Mm-hmm. Yep. And there's one on this is his right leg, that little black mark was brought up as in the second trial. And they were trying to attribute that to an impact site. But again, there's no bruising there. Nothing. Absolutely nothing. It looks like a cigarette. Someone's put a cigarette out on his leg. It looks like a burn almost. But that's never been investigated any further. And it's certainly not an impact zone. So that was the only injury he had on his lower extremities. Apart from all the arm stuff. What was this one? I don't know if you've seen that one. So yes, that picture right there, that really, if he was actually, if they were attempting to resuscitate him, he was in that fucking house. You're not going to do it on the front lawn, are you? No. He didn't get it in the ambulance. I've got all the first responder stuff. Let's have a look. So this is all of their testimony from Anthony Filati, Matthew Kelly, Francis Walsh, and Katie Milne. All of them. None of them say attempted intravenous access to right arm at all. Not one. They didn't even really have time, because by the time they got there, they basically just maintained the CPR, got him onto a stretcher and put him into the ambulance. Just reading through to see if there was anything. Walsh observed 2 upset women, with one screaming, "Is he alive?" He noted O'Keefe was missing his right shoe, and in the ambulance saw a hematoma on his right eye and blood coming from his nose. Okay, Walsh was responsible for the IO. Okay, that's the I can never say that word. Intraoptical, I don't know. It means in the bone. And that's how they gained access to give him the epinephrine and normal saline to warm him up. He told Sergeant Good that there were signs of trauma on the patient. Observations regarding Karen Reid. He did not hear Karen Reid say, "I hit him." Below describes the positioning of the ambulance. He observed 2 women near O'Keefe's body. It was found supine about 10 feet from the road. Now, there are multiple testimonies that state between 5 feet and 10 feet. They differ in from that much. CPR was initiated. Due to the weather, the priority was to move O'Keefe into the ambulance to begin warming. I mentioned the use of a valve and mask for high flow oxygen, the intraosseous needle for administering fluids and epinephrine. No IV access to the peripheries. Nothing. blood. He observed hemorrhaging from the mouth, eyes, and nose, and he noted the body was cold and wet. Hospital transfer to the Good Samaritan Medical Centre, reported that his body temperature was 80 degrees. Now, I actually did a whole thing on that as well a while ago. I actually put in a heap of criteria about John's body temperature at the time that he was found, about the position of his body, the weather conditions at the time, his clothing, his height, his weight, his blood alcohol content levels, and his vitreous enamel blood alcohol levels, his body temperature when he was found and at the hospital, his injuries that he'd sustained. I put in all of the parameters basically, and it came up with the answer that it's almost like reading Gordy Bellow's report. Oh, and the fact that there was no frostbite present or anything like that. It takes about 2 to 3 hours for frostbite to become evident. So there is no way that he was out on that lawn at 12:30 and found at 6:30 without having anything that even resembled frostbite at all. And from those parameters that I put in the search, they basically said that his time of death was around the 12:30 mark. It had been at least between half an hour and an hour since he had consumed his last drink of alcohol. And it had the whole formula of how fast a human body temperature reduces in normal conditions, as in, like, the same body temperature internally as externally. So if you're sitting in your lounge room, you know what I mean, like the temperature you're currently at, and then how it would, the ratio and formula of how that would be altered in different environments, which is what I'd added to the scenario. And it said that at the time that he was found, because I gave them no other information bar the time he was last seen and the time that his body was discovered, they said between 5 and 6 hours that he had been deceased, which is perfectly aligned with the timeline, funnily enough. But the loss of blood, that from the autopsy, it was 3 litres he had lost, and there is not a hope in and around where his body was that there was 3 litres there at all, and certainly wasn't 3 litres in solo cups either. So now I saved a few other things. What was this one? Can't remember what this is. Oh, okay. I think it's the non. Oh, okay. So this is more examples of. Hang on. This goes back into all of his. Okay. So this is the medical examiner's notes from the autopsy showing exactly what John's injuries were. And that's where I got all the information with regards to put into the calculation. So he had 2 intraosseous devices. Stop it. Pause. Thank you. If you look down to where his knees are, and then you'll see on both sides of the frontal picture of him, it says IOL, IOL. Okay, that is where they have the intraosseal devices. So there is not a place. There is not anywhere on here that says IV cannulation into any hands. It does say a 2 centimetre bruise to his right hand, and an ID, a 3 centimetre abrasion to his right, just under his arm there. They had the defibrillator pads on. So go to the next one. So this is from Irene Scotti-Bello in her autopsy. Okay, so this is the inside of a skull. It's not his, but it's just showing how taken it from above, how the blood can go out of the skull itself and get pushed out into the eye sockets. And then I give you some examples of comparative injuries, okay? So this again is caused by the blunt force trauma from back and the impact to the front on the inside of the brain. They're commonly known as raccoon eyes. And you can see the difference between that and having the living crap beaten out of you. There was another example, okay? Same thing, blunt force trauma from the rear. All right, now I have a shit ton of findings that I have lumped together. Let me just find them. I'll have to bring them up because there was too many for me to preload basically. All right. Okay. I did protocols. All right, let me share this screen. Okay. Let's zoom in. zoom. Okay. So I went back then and did an analysis. This is all done like 6-7 months ago. But I did an analysis on what the normal response times were in Massachusetts, particularly in Canton, for crime scene investigation and for CERT responses, basically. So the analysis of the protocol violations in the Karen Reid case based on the information gathered from multiple sources. There are numerous protocol violations, irregularities, and concerns related to the investigation of John O'Keefe's death and the subsequent prosecution of Karen Reid. These violations span across various law enforcement agencies and stages of the investigation. So, the initial crime scene response and processing. The scene documentation and photography, failure to photograph the victim at the original location. There was no crime scene investigation or crime scene process done. The police officers did not photograph John O'Keefe at the location where he was found before the fire rescue moved him, and the first responding officers should have photographed the scene and body before any movement, and none were taken of the exact location and were found use of personal cell phones for crime scene. Yeah, they could have quite easily picked up their phone and taken pictures. The Canton PD officers used personal phones to photograph and video evidence collection, which is fine. They didn't have anything else. Department policy specified that digital camera or laptop computers should have been used. Well, they would have had crime scene investigations been called out to investigate. Officers reportedly did not initially treat the scene as a potential hit and run or serious crime scene. The initial response was characterised as a man in the snow, which was what Jen McCabe had said. There is a man down in the snow, when she knew damn well who it was. Laptop computer should have been used. Personal device. Chain of evidence. Integrity concerns. Obviously, officers reportedly did not initially treat. Now, keep going. Despite the victim's significant injuries, evidence collection and preservation, improper evidence collection of materials. The detectives used the red solo cups. Yes, we know that, but it doesn't make any difference. No Bureau of Criminal Identification units were initially on scene. Crime scene kits were not available or used for any evidence collection. They were not properly equipped with evidence bags, blah, blah, blah. Discrepancy in the timing of when Karen Reid's car was seized. That was the 45 minutes missing from Proctor's affidavit. The taillight pieces were discovered in the Albert Yard during a night search after Reid's car was already in police custody. Additional taillight pieces reportedly found a week later. Crime scene security failure to maintain crime scene security. Neither the MSP or Canton PD maintained proper police presence, and no officer remained at the scene pending further investigation. They failed to secure the residence following the 911 call, and no coordination between agencies to maintain the scene integrity. Witness handling and interviews were improper, and they were combined together. Canton Police allowed Jennifer McCabe to enter the McAlbert home to wake residents before police entered, and they interviewed them together. Critical witnesses were not interviewed at Canton PD on January 29th. Nicole and Brian Albert should have been interviewed rather than at the scene, and Colin wasn't interviewed until 18 months later. Police conducted a brief 10-minute unrecorded joint interview with McCabe, and the Alberts' consensual recording witness interviews should have been conducted. The later interview with Colin was unrecorded. Video footage of Karen's Lexus housed at Canton PD. Oh yeah, we all know that. It was inverted. Missing security footage from the library. Proctor had, oh, okay, so investigator conduct and bias, conflict of interest. MSP Trooper Michael Proctor had personal connections with the Albert family dating back to 2012. His sister had communications. Yeah, we all know that. Reid was rearrested and upcharged with second-degree murder months after the initial charges. DA requested $500,000 bail. Raleigh allegedly assured the court that Proctor had no conflicts of interest despite evidence of social connections. I thought this was a different report because basically it was, I put in there what were the average response times of the CERT team in that area. And the response to, I found the wrong one, sorry. The average response was 1 to 2 hours for the CERT team to respond to any call out, regardless of the weather, because that is totally normal kind of weather. Like snow in Massachusetts isn't a factor, and it shouldn't be in a crime scene either. It's better. So instead of it taking them 1 to 2 hours, it took them 12. They had to wait for the green light to get the go-ahead to go and do their job. So the reason I bring that up is because the opinion that there had to have been like 300 people in on a cover-up story is false. The only people that were involved were basically up to Proctor and to a lesser degree, I think, Buchanan and Tully. But initially, if you've got all of these things in place, so you've got no one there to secure the scene, you've got no one then looking for any other evidence to be found, so there is nothing to prove that anyone else did it. There is no, they can also then claim that if anything was found in the future, that it was contaminated from the scene because it wasn't secured. They allowed time, like the April 14 allowed time for anything to be cleaned up inside the house. And then 12 hours before the CERT team was set out, that allowed time for them to actually obtain these taillight pieces and get them back to the crime scene. And that's where the knowledge ends. So the CERT team weren't involved. They didn't know. They're just doing their job from then on, and it just perpetuates from there. I'm sure I had this thing. Yes. What's that? Let's see what that is. Share screen. Oh, yes, this is where I wanted to lead into, because this is where Proctor's role is extremely important, because he's the lead investigator. He is the one that sends all these people out. Yeah? So, let's get some context. We are... Hang on, need a drink. Yeah. Okay, so John's body has been found, been transferred to Good Samaritan Hospital, and Michael Proctor has been assigned as lead investigator. So John's body was found at 6:30. At 1 p.m. on January 29th, Michael Proctor arrives at the Good Samaritan Hospital with Buchanan in tow. Okay? Now, they didn't go to 34 Fairview. They went straight to the hospital. So, assuming that they have not spoken to anybody at 34 Fairview, these things need to, this assessment that he does here leads him to these conclusions, okay? He arrives at the hospital at 1 o'clock. And let's assume he has not spoken to anybody. They went to review his body. They were informed that he was deceased and that Karen was, she'd been released. Okay, so during his testimony, Proctor described what he'd observed. The first thing I noticed on Mr. O'Keefe is he had abrasions on his right arm. On the top of his right arm was approximately 6 to 8, ranging from his forearm to his lower bicep. And he observed, Proctor and Buchanan observed injuries prior to his visit to the hospital. Proctor had not personally seen any of O'Keefe's injuries. After reviewing his body, he testified that they observed a pile of clothes in the corner that the hospital staff had cut off Mr. O'Keefe and piled them into the corner. One thing that jumped out to both of us was that he had one sneaker. Proctor noted that this is fairly common in a motor vehicle pedestrian strike to lose footwear. So they apparently collected the clothing as evidence from the hospital, and they went into the back of Buchanan's truck, back into the footwell, and they were there for quite some time. He also came into possession of O'Keefe's phone, and though he testified this was received at the Canton Police Department. All right, the context. So his hospital visit occurred the same day the body was found, and earlier that morning he was notified about the case, initially described as a possible medical situation. He contacted Detective Lank for more information, and then after learning John had been transferred to Good Samaritan, he decided to go there instead. Okay, they go straight to the hospital. Up they trot. Proctor personally observed O'Keefe's injuries and collected evidence, including clothing items that were later transported to the crime lab on March the 14th. Yep. 6 weeks later. Aha. Thought there was more to that. Anyway, but so he said he has spoken to Lank, and who's the other person? Must have been whoever called him out. So he's been told that it is a possible medical situation. From his observations and evaluations of John O'Keefe's body at Good Samaritan Hospital that morning, he deduced the following. A, that it was a vehicle pedestrian collision. Because he had one shoe on. He also determined that it was Karen Reid that had caused this, that was responsible for the vehicle pedestrian collision. And then he went straight to Dighton to collect her and the car. How do you go from a possible medical condition to first-degree murder of someone that he's never seen or heard of before? How do you know that tail light was cracked, even? What made him suspect her? How do you whip that up out of your head from there? And how do you deduce from there, with one sneaker, to the only possible scenario was a vehicle strike? You can't, because it doesn't make sense. There would have had to have been a phone call from Brian Albert himself to get Proctor up to speed, to fill him in on all the details. And from there on, the investigation played out. They didn't need to involve anyone else in the story because the story was done. They just needed to maintain their basic truth, like their basic explanation of the events. And that's why you see so many discrepancies in the details, because they all couldn't keep the same story, especially not after the second trial. And it was that night too that Proctor had the text messages with his friends on as he was going through John's phone, and he told them that, you know, he was going through looking for nudes or something. But that's also the time where he has called Karen all these horrible names. He's never met her before. How the fuck would he even know what her personality was like? And then he states in his testimony at court that, you know, he was upset because he, how did he put it? Drive me mental. He made some comment about, you know, how he'd found all this information about her. He'd made his mind up about her because he found out this information of what had happened, like how she had hit him with a car and left him to die. But he hadn't heard any of that information because that was a night. So nothing had been investigated. Nothing had been proven. Nothing at all had happened. And he has made this huge assumption of her personality. And, you know, I can't even remember what the comment that he actually called her. It was... It involved the C word anyway. You all know the texts that I'm talking about. But yeah, they were all done that night. So he had this huge amount of information on Karen Reid, someone that he obviously never heard of and never met before in his life. How did that happen? Well, I reckon I know how that happened. But so at the end of the day, we are going with snake bite. And Article 14. Mr. Albert's extra layer of insurance. Hang on. I will take this off so you can see. Oop. Exactly, Brian. Why? I reckon I know. Just saying. All right. I have made my case. Yet again. I hope that made sense. Trying to explain that sort of stuff is hard. For me, having that scientific background and the medical background, I view it differently. And so it's the little things. I can't find any other explanation why he would have, or how he could get to, like, needle prick marks in the back of his hand where you would normally cannulate someone to gain access. I don't know how else he could have achieved those without that happening. And if that was attempted, it had to have been done before he was deceased because it's bruised. The only way it makes sense is that it was done as an attempt to resuscitate him in the house when he's started vomiting and convulsing. They've gone, oh, fuck. Quick, get my first aid kit. And it wouldn't be unreasonable to think that he would have, being a, trained first responder, that he had a quite inclusive first aid kit that included some basic IV resuscitation, normal saline, whatever. And the fact that there was a fucking nurse there. Sarah Levinson. Ryan might not have been able to do, he might not have been qualified to do that cannulation or didn't know how to do it, but sure as shit guarantee you she did. So, yeah. It's food for thought. And in my opinion, it shows that you don't have to involve 300 people for a cover-up. And I don't think it's a conspiracy. People have labelled it incorrectly. It's a cover-up for what's happened at the house. And if there wasn't a cover-up, how do you explain every single anomaly in the investigation after that, including, we know Brian Albert had CCTV cameras at his house. Never seen. We know that the neighbours were never even canvassed. The crime scene didn't get processed. There was every possible opportunity where Karen's taillight could have been recorded on CCTV footage, miraculously disappeared, including the 2 minutes that it would have passed by the library in Canton on her way home. The 2 ring camera videos at One Meadows where Kerry and Jen inspect the taillight. And when she gets home from Meadows, they're both missing as well. At the end of the day, not a coincidence. And then you have the mirrored CCTV at the Sallyport. Why? Why bother if you've got nothing to hide? Who's going to invert that? And who's going to make the quality of that video so bad that you can hardly see it when it is something, it is used for police protection in a Sallyport? Why try and alter your timeline in your affidavit by 45 minutes from when you picked up a car to get back to the Sallyport? Why didn't you take pictures of the taillight at Dighton while you were there? It does not. The reason that everyone's saying that it was a really shit investigation, no. It was a deliberately shit investigation because if you don't look for it, you're never going to find it. You don't look for the possibility of there being any other evidence to implicate anybody else, then there is no evidence. And the only evidence there is what you provide. It's as simple and as easy as that. It doesn't go any further. I initially thought that Buchanan wasn't that involved in it or didn't know as much as I thought he did. But then in his testimony in the second trial, he knew. He knew for sure. And Brian Albert would have pulled in that favour all the way up the line. And then everyone just did as they were told. That's it. It's easy as that. So there you go. All right. Well, I hope that has been informative. Next week, Miss Tricia, I will speak to you over the weekend. But I think we start sharing. What do you reckon? You up for it? I have not even, this is just stuff that I literally went into my my file and stuff that I had done 8 months ago and researched it and followed it and never presented it. Never. All that stuff that I pulled up today is stuff that I had done the first trial, pretty much. And then I added to it with the second trial in the database, and I've got comparisons of every single day of trial. Every witness. I compared their testimony in the first and the second trial and what any differences were. Every single one, and more. Yes, I have put a shit ton of work and research into this case, and that's why I can wholeheartedly say there is not one cell in my body that proves to me or even alludes to the fact that Karen was guilty at all. So there you go. All right. Well, we'll keep that notification bell set to all because we've got some really, really good stuff coming. Stuff that no one's ever seen before. Stuff that is going to blow your mind. Literally. All right. Oh, and I probably should. Where is it? I've got a couple of things on the burner, actually. We've got this huge 30-year-old case that is just going to be massive. But we also have a new, what do you call it? I don't even know what you call it. What should we call it, Edith? What? What is it? It's not a channel. It's a... hang on. Let me find the promo. There you go. Fuck. Oh, it's up here. Come on. Video. Full screen that. Thank you. Video. For the record. Okay. Oh, how do you like this? I have made this up for any violations. You ready? And this one. For the timer. And have a look at this. Oh, shoot. It's not going to play. You're not going to see my screen unless I share it. Idiot. Such an idiot. I've put it to play on my screen and not yours. Oh, fungal. Videos, Jody. Video. One. Now, go back to here. Thank you. And there we go. I can share that now.
Let's get ready to rumble.
Now, if that doesn't excite you, I don't know what will. So I don't know if the link for the application form for expressions of interest is actually connected to that. I'm going to post this after this and we'll see. But I'm going to put a copy of the application form in chat now so that it's there. I'm just going to fucking find it. F. There. Contestant application, copy, and paste. No, not working there. Let's see if it does it in here. Paste. Nope, not working there either. All right, let me put it in description box. Okay. Application form for debate contestants. Okay, paste it. So the link should be, oh, you fucker, what? Why won't it copy and paste it? Share the PDF. Fuck. Well, I don't know how to do it. Fucking computers, fucking technology. Just fucking. I'll find a way somehow. That's what's holding me up from promoting this, because I don't know how to bloody do it. I don't know how to put that there and make that work, and you know, and my headphones keep falling off my head. I'll allow that. That's fine. Oh, no, you can't. No personal insults, but you can call their opinions twattic. I find your opinions somewhat twattic. All right, I'm going to bed. I will try and find a way to put this video, this bloody application form out somehow, somewhere. Got any suggestions? Let me know. So I can't work it out. I can do all the graphic stuff. I just can't attach a fucking document to it. All right, I'm done. That's all, Mr. Bitches. Have a good weekend. See you Monday. Bye.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.